Welcome to our Super Stunk AMA with former SEC branch chief Lisa Braganca. Usually Jay Smart does these, and I was going to join him for this one, but he's feeling under the weather, so I will do my best all alone. All right, so tell us about yourself.
Well, my name's Lisa Braganza, and I am now an attorney. I represent people in SEC investigations. I do a lot of investor advocacy work. I try to help people recover losses if they've run into, fraud with a broker. And in my free time, I really enjoy doing this kind of advocacy work. I come from, I have an MBA and a JD, so my brain kind of works in both of those different ways. Depends on the day. But I was at the Securities and Exchange Commission, and while there, I handled investigations of potential securities law violations, and got to see, kind of some of what was under the hood at the SEC. Now, that was like 20 years ago, so things have changed a lot. We have this thing called the internet now that's just, so much more prevalent. I mean, way back when I was at the SEC, we used to work with the FBI, and they weren't allowed to have access to email or the internet. Yeah, it was that new. So, it's a different world, but I keep up with it because I represent a lot of people who are being investigated by the SEC.
All right, so for the regulatory process, let's start this off with the general regulatory environment. What are the top obstacles a financial regulator faces when it comes to enforcing a fairer, more transparent system?
Well, thank you, by the way, before I get started. Thank you so much. I am honored to be here, and I am very impressed with the questions and delighted to answer. There are three big problems that a regulator like the SEC and some of the other financial ones, the CFTC, that they face. One is resources. Two is the incentives that they're facing. And the third one is they got to get support from people outside. So let me go back and go through each one of these. The first one, resources. Now, this is the government. And when the government is taking on big players, those big players have huge resources. They have the ability to throw lots of lawyers and lots of experts and money at a case. The government just can't keep up with that. Even though it looks like they have, inexhaustible resources, they cannot keep up with the really big players. So the second problem is that there's this incentive issue. Regulators are people, and enforcement lawyers are people, and they know how to do certain types of cases really well. They've done them, it's sort of like just riding a bike. But other types of cases are complicated and difficult, and they might take up a lot of time. They might, frankly, make you feel stupid doing it because you don't know what you're doing for a while. And so that's a reason that sometimes enforcement might shy away a little bit from super, super complicated cases. Another reason is that those cases tend not to be as sexy, and the SEC Enforcement Division absolutely loves to do cases in parallel with, or not, they don't prosecute them with the Department of Justice, but they have parallel investigations in which the SEC hands over wholesale everything that they've got and pitches the case basically to the Department of Justice. And, think about how easy it is. Once somebody gets indicted, it's kind of easy to make your civil case after that, because the level of proof for civil charges is so much lower than the level of proof for criminal charges. So anyway, but if you have a super complicated case, then the Department of Justice doesn't have time for that. That's just too difficult. It's too hard to prove intent there. The last reason is that the regulators don't hear a lot from retail. They do hear almost every day of the week from the industry. The big players have trade associations. They have, they'll come in individually. They have meetings. They have, they know what is going on the regulatory side inside the agency. They've got their finger on the pulse. And that makes sense because that really makes a difference in how much money they make. If there's a regulation that's pending, they are going to want to know ahead of time, what's it going to cost them? How's it going to affect their business? And what can they do to shape that to their benefit? Sometimes the industry orchestrates letter writing campaigns and they do all kinds of things to make this happen. And it makes something happen that they want. And so now you think, okay, well, the SEC's hearing all this information, they're getting all of these letters, they're getting all of this input from the industry, but how much do they hear from retail? And I do have to tell you something, Platt. This was just, it was a joy to see. I know that over the last month or so, we've been talking. I know I've spoken a little bit about putting comment letters in. I know other people have been talking about comment letters. And in preparation for this talk, I just hopped online and was looking at some of the comments. And I noticed that on February 7th, 8th, 9th, there were a ton of comments from retail on this proposed regulation. And I have to tell you, I almost cried. I am just so thrilled. It's incredible. It's wonderful. So that is huge. And what you're doing is there's this seesaw, and right now industries, got all this weight here and you're evening it out. So that's just wonderful.
Nice. I'm guessing that's the short reporting. Yes. Yeah. Okay. Yeah. I figured. Oh. All right. Let's see. There's been a great deal of public criticism of the SEC for issuing seemingly insignificant fines to major players, with Wall Street essentially treating it as the cost of doing business. I'd love to hear your thoughts on this topic.
This is a tough one. This is a really tough question. It's hard because we are dealing with sanctioning dealing with wrongdoing within an entity and this company that is made up of people. So that tends to be the real struggle. Is punishing the company the right thing to do when the company acted through its individual employees? Now, I'm not going to abandon that, but that's just, it's pretty well resolved. And I think, we know that companies do get punished, but there's some question of, how much. The second question is, when we impose those fines on the company, who really gets punished? So let's look at some of the major brokerage firms that have entered into settlements with the SEC and with DOJ even, and with deferred prosecution agreements. They've paid large sums of money, and some of their names are JP Morgan, Wells Fargo, Citibank, UBS, they're all ex-cons, really. I mean, they have agreed to settle or pleaded to criminal charges. So now let's think about, or let's look at what's happened with their boards of directors, what's happened with their CEOs. I don't really see that they've been punished, even though they've been presiding over the company during this bad conduct. They continue to make money and continue to remain in their positions on the board of directors. And so that seems kind of perverse. So it's really just the shareholders. I mean, the senior management, those people who were in control of the company, are not being punished when the company's paying a fine. It's the shareholders who are ultimately being punished. So that's a problem with just upping the fines. Another problem is sometimes the government needs cooperation from the company. If you think about doing an investigation, let's say, you have SEC folks who are investigating activities on the trading desk at JP Morgan, and they get a whole bunch of documents, paper, whatever, files. They're trying to figure this out. What was going on? They have to put that together with, emails or whatever, how do they figure it out? It's hard. And they need the cooperation of the company if they're going to figure out that Joe was actually involved in some kind of wrongdoing, whatever the trading, if he was manipulating, bond prices. Well, it's going to be damned hard for them to figure it out on their own, but they're going to do pretty well, if they can get the company to interpret its own records and tell them what's going on. Another problem is there's got to be some kind of an incentive now for companies to institute real controls. So if a company, let's say we decide companies are not going to have penalties at all, well, they won't bother to put the time and effort into do some kinds of controls. So that's the argument of don't hit the company at all with any penalty at all. So we gotta have something there for the company, some incentive. So let's think about, what are alternate things that we could do? Well, we have a really good example from, the last 20 years or so of really coming down on a company. And that's Arthur Andersen. And, you might not remember, but when Enron happened, Arthur Andersen was the auditor. And the Arthur Andersen, but anyway, there's dispute maybe about what the facts were, but basically Arthur Andersen got indicted for destroying records, telling staff people to shred relevant information about the audit work papers. Basically, they were shredding them. That really did upset the Department of Justice. When that there's an investigation going on and you are actually actively at the shredder feeding the papers in, that made them very unhappy. And that instruction came from a lawyer, actually at Arthur Andersen's headquarters. So that's a pretty good set of facts for holding a company liable. I will give you full disclosure. I actually worked at Arthur Andersen many, many, many years ago on the consulting side, and have opinions about that. But I just will say that I want to get that out there. So what happens? Arthur Andersen gets indicted, and that means Arthur Andersen cannot be doing audits of public companies. So the company basically, shrinks from being one of the biggest auditing and consulting companies in the world to now only being able to do audits of and work for private companies. This caused huge dislocation in Chicago. I mean, this is the headquarters of Arthur Andersen worldwide. And a huge upheaval and lots of blowback that the Department of Justice had to live through. I wouldn't be surprised if there were death threats, because it was very upsetting. Lots and lots and lots of people lost their jobs, and lots of practice groups went and found their way to other, other organizations, other auditing firms, but huge dislocation. Since then, I think there's been a lot more hesitation by the Department of Justice to actually, this was kind of the death penalty. So it's hard when you do something other than a fine. It's in essence the death penalty. So this is a really tough question. I guess that's the answer I have to give.
It is a tough question.
It's really hard. We could have, I mean, as I was thinking about this one, I was thinking like, well, what if we had a law where if a company gets indicted, let's say, or settles, enters into a plea agreement for criminal charges, that the CEO and the entire board of directors get kicked out and they have to give back the money that they've earned for the last whatever period of time. Like, that's a possibility, right? That's a hypothetical. But now we have to look at what are the collateral consequences, like the unintended consequences. And, then you think, well, would a company ever cooperate? And wouldn't then the CEO and the board of directors have the incentive to just always fight to the death? Like, because for them, it would be the death penalty. So these are the kinds of things that, it's hard. I guess that's the end answer is it's hard, Platt.
Okay, one of the most surprising discoveries for retail was the existence of self-regulatory organizations. Do you think there should be more regulatory oversight of SROs?
Oh my, yes. Let me tell you all about the SROs and then we can kind of go back. So self-regulatory organizations are kind of wacky. They are sort of vestigial organs of the pre-securities law, pre-federal securities law realm. We have the laws that we have today because, they were basically what came out of the Great Depression. We had the big stock market crash, and then there was an investigation that happened, and Congress looked into it, and then decided to pass a couple of different securities laws. But things like the New York Stock Exchange already existed. Like, the New York Stock Exchange actually has existed since, I think, the late 1700s. I can't remember the exact date, but been around a long time. So, when the federal legislators decided to do something, they kind of layered on top. So that's why we continue to have these, we had the old ones, and then they created new ones. So the biggest one that we deal with now, FINRA, was originally the National Association of Securities Dealers, NASD. And so FINRA today has a whole lot of power. It isn't just, it's not like the New York Stock Exchange, which was a trading floor, but also regulated the activity that went on. The FINRA, the former NASD, is a sort of the policeman, but also the rule maker for all brokerage firms and their employees. So that's kind of a big, it's a huge organization, and it's got a whole lot of real estate that it's responsible for. So why, I can't honestly tell you why it made sense to create this kind of organization. I mean, it certainly came after the securities laws were entered into, and I think part of it probably was a result of industry advocating for that and saying, hey, we can take care of that, just like the New York Stock Exchange is their thing. Well, look what a great job they've done. Let us create this other organization, and then we'll continue to do it. But FINRA has developed a huge amount of control over the rules for how brokers can operate. And they don't just make the rules, though. They also enforce the rules to some extent. So that's kind of an interesting thing that they do. But the thing that really gets me, and you'll see this is something I will come back to again, is that they also have complete control over the forum in which disputes with customers have to be resolved. When you look at your brokerage account statement, you'll look at, Interactive Brokers, Robinhood, doesn't matter. They all require that you resolve your disputes in FINRA arbitration. And those FINRA has made all the rules that cover that. Those rules were made without your input. They certainly were made without my input, but they were made with the input of the industry. So that's a kind of wacky thing that has become much more important because, way back in the 1970s, this is like ancient history, but in the 1970s, the Supreme Court came down with an opinion that said, yeah, we can have lots of, arbitration, that arbitration is a good idea. And so now we have all these disputes being decided outside of that. So now let me get back to the SEC has got to step up its supervision of FINRA. There was just a report that came out in December. The General Accountability Office, I always want to call it General Accounting Office, but it's the General Accountability Office, GAO, issued a report in December 2021, and it recommended some pretty significant changes that for the SEC to implement in how it oversees FINRA. What the GAO found was that that the SEC's oversight was really, it sounded to me like sort of ticking boxes, oh, did you do this activity? Did you do this other activity? And it wasn't the type of supervision that really pointed out results and looking for, the way they put it, performance and outcomes. So now this report is the public version. I can assure you I would love to see the real unredacted, report that's circulating within the SEC and at the GAO, but I can't see that. This alone, though, what's come out publicly tells us that SROs definitely, we need more supervision. I can give you some other specific examples that the SEC should be looking at more closely, and frankly, they should just take them away from FINRA. This is an area I look at a lot. So, SEC and lots of others, they tell people, if you're going to hire a broker, you should look at this thing called broker check. And on broker check, you can research, do due diligence on that prospective broker. So you would expect that the information that's on broker check would be accurate, right? That the SEC would want to make sure that it's accurate. I mean, the SEC is a full disclosure and transparency agency. But the SEC is aware that there's a whole lot of information that's been purged from broker check that's really important, and that's customer complaints. And they know about this problem, but they have not fixed it. So this, now I bash the industry a lot, and I certainly, bash FINRA because it is owned and operated by the industry. And, it's, at least we have the SEC that is supposed to be there supervising it, and hopefully the SEC will step up its game and will supervise it a little more closely.
It is tough. Since you've left the SEC, what's your opinion on how the system has changed over time, specifically pertaining to the asymmetric balance between Wall Street and retail?
Wow, this was another really hard question. Well, when I was coming out, we had so much less online information. I mean, we actually were doing, we had this thing called blue sheets where, you would get trading data from the broker dealers, and they used to be on blue sheets of paper. That's why they were called blue sheets. So we used to get that information, electronically, but boy, it wasn't like today, where you just can get it super quickly. It still was just a little step from the pieces of paper. So we didn't have online brokerages, really. I mean, Charles Schwab was a big deal. There certainly was nothing like Robinhood and interactive brokers. And we were dealing with the dot-com bubble bursting and Y2K. Can you believe that we thought that the entire world was going to come to an end, because of the flip? Yes, but it was serious. Like, that was craziness. At the SEC, people were running around like the sky was falling. We didn't know. And there were a lot of accounting fraud problems. So that was the big question then, there was a lot of cooking the books. And that was stuff I worked on. And I kind of liked that, even though it made me feel stupid a lot, doing accounting fraud cases, because it's so complicated. And, I would have to work like arm in arm with an accountant who would have to tell me the same thing over and over again. Like, what? How does that work? And I took accounting, but still, this is complicated stuff. And these people, these companies really know how to cook the books. So that was a whole different world. Now, I will say that, and that was like pre-Enron, and then Enron happened. So there was a whole lot of craziness there. In terms of asymmetries in information, I think it's gotten worse. And the reason is because less information, there's just less trading on lit exchanges. I mean, it is amazing to me that we can have this much trading happen away from the public exchange. I mean, the whole idea of our markets is based on a bunch of guys, just like in the movie Trading Places, running around with pieces of paper in their hand, yelling, buy, sell, whatever it is that, and doing trading like out in the open. And now we have everything happening so very quickly. And maybe it is more public in terms of, you're getting information more quickly. It's not like the old ticker tapes. They used to have these tickers that would, print out on little pieces of paper, and you would keep going through it. And this was before my time, by the way. That is way before my time. Like we had other ways to know what the stock prices were by the time I started. But so it is a difficult thing to sort figure out the exact asymmetries. I think today we are awash in information. What we can get is, we don't have to wait for the newspaper to know what the closing price was on a stock. We can get it right away. By the same token, who cares what the closing price was? Because it's the relevant price is what the high frequency traders are looking at, all those trades during the day. So it's another hard question.
Thank you for answering anyways. Do you believe that more people should have been prosecuted for their part in the financial crisis of 2008?
I do. I do believe more people should have been prosecuted. I think there were way too many people who got away with just very reckless, if not actual intentional fraud. But I understand why not enough people were prosecuted. And here's the classic example. It really is the case that had a big effect. First, it's complicated to bring a case again against even individuals who work for one of these big entities. These individuals have a lot of money, so they hire good lawyers. The brokerage firms are going to hire big lawyers, and while the brokerage firm might seem to be cooperating with the government, they might not really be cooperating with the government. So it's very hard to win these cases. Now, let's think about, what if the government loves to get settlements, and they do get lots of settlements, and that's a really great thing, because that means that both sides avoid the uncertainty of going before a jury. But if you have to go in front of a jury, and you do have to prepare your cases as if you're going to go before a jury. So here's an example where, the government, if you remember Bear Stearns, that may be long ago, but back around, 2007 or so, there were a whole lot of these things called collateralized mortgage obligations, collateralized debt obligations, and they were mortgages that were packaged up, sliced and diced and packaged up and put into these nice little packages. And then a couple of guys at Bear Stearns had a fund, and they were stuffing these, CDOs and CMBSs and all kinds of stuff into this fund and selling it to retail investors. And when everything blew up, big surprise, that fund blew up completely. And these two people, Ralph Giaffi and Matthew Tanine, were prosecuted by the Department of Justice. And the SEC assisted in that. And this was a huge case that was brought. And they were acquitted. And that was a big black eye for the Department of Justice and for the government, for the SEC. I mean, it was tough. And basically, when people interviewed the jurors afterwards, some of them said, look, we thought that these two guys were being scapegoated. The whole company was in on it, and we thought they were being scapegoated, so we weren't going to convict. So that's the kind of thing that, maybe it shouldn't have shut the government down, or maybe the government should be more willing to try cases and lose them. There's an entire book about that. But that is a reason that, the government thinks long and hard about bringing a super complicated case against a company or against, some people like Giaffi and Tanine.
Yeah. Given that there is a constant revolving door between regulatory bodies and the financial institutions that they are supposed to regulate, how can the public ever be confident that those writing and enforcing the rules are doing so to ensure fair markets and not for the interests of their future employers?
Boy, that one hits close to home, because I was in the government and now I am on the other side of that door. But it's a good question. It's a combination of, there's the reality of a conflict and there's the appearance of a conflict. And look, I was at the SEC. I learned how the SEC works, and now I'm on the outside, and I use that knowledge of how it works to hopefully benefit my clients, and certainly in my advocacy work. But we have to look at the incentives here. What if we had a system where if I went to work for the SEC, I could never work in the private sector? I don't know if I'd ever gone to work for the SEC, because it would be kind of like the Hotel California. Like, I could check in, but I could never check out. I don't know how my bosses might have treated me when I was at the SEC, if they knew that, like, hey, you're stuck here, you're never going anywhere. So we get to give you, do terrible things to you. So we have to have some way for people to be able to get out and do things in the private sector. And the SEC wants to attract people to come in. Now, they have done that because they pay big bucks these days. SEC employees and attorneys and all that, they make a much more than when I was there. And that's good, because, that brings people in who have some really very good experience in trying cases, in investigating, in working on Wall Street. So that's a good thing. Now we have, and one more thing on the reality side, there are ethics rules that limit it. Like, when I left the SEC, there were certain things I couldn't do. I certainly couldn't work on, go out and defend somebody who I had been investigating, or somebody who worked for me had been investigating. Like, that's a big no-no. And that's a no-no both from the government ethics rules, and it's also from the lawyer rules. Like, that's a no-no, even between two private parties. So that's the reality side. Then there's I think that is the bigger issue that this question really drives at, is the appearance. And that's a much, much harder question to deal with. Yes, it looks smarmy. It I think we need to figure out how to make people confident that and maybe disclose more of the ethics rules that apply to former government employees and enforce them. But there definitely are. And if you are, a responsible grown up, and certainly if you're a lawyer and you want to keep your license, and I definitely want to keep my license, you follow those rules, because you don't want to end up getting kicked out of, the lawyer guild.
Yeah, that makes sense. Can you talk about how mandatory arbitration has made the securities industry more powerful?
Oh, yes. Yes, mandatory arbitration is the bane of my existence. Before I launch into it, there isn't anything wrong per se with arbitration. If you've got two big companies that want to decide their dispute outside of the courts, more power to them. But mandatory arbitration is just that, mandatory. Well, why does it have to be mandatory? Because you're trying to force it down someone's throat. Right? I mean, how can we say mandatory arbitration, but then say that parties are voluntarily entering into it? It's sort of an oxymoron. So mandatory or arbitration, FINRA arbitration, is a way that the industry has been able to hide a ton of what it's doing. When you think about, you file a case in court, you put your complaint in there. If I'm representing a customer, an investor, I'll write out what the brokerage firm did, and that gets filed with a court. And there are lots of people who read that stuff. It's public. Anybody can come along and read it. And there'll be briefing, and there may be a further description made public, of what the conduct was. Now, it's disputed, but still, it's out there. And that's something that the industry completely avoids by having it in arbitration. Those complaints, they're called statements of claim. You file them with FINRA, and the public doesn't get to see them. Now, I suppose I could just post mine on my website, the ones that I do for my clients, but it is a private system. It's a non-public system. And why should we be deciding these kinds of disputes outside of sunlight, so that we can disinfect the system? Now, another problem. Now, there's a couple of reasons that not having these disputes decided in public really matters. One is that brokerage firms say the most outrageous things in their briefs to arbitrators, and they can get away with it because it's not something that they're really held accountable for. The other thing is that there's no precedent. So it's like Groundhog Day. You can have a gigantic problem, like, for example, UBS had products in Puerto Rico that, turned out they were clearly the same product being sold to lots and lots and lots of investors in Puerto Rico. Same problems. Now, if this were court, the first cases would go through, and then there would be certain precedential sort of decisions made. And then all the people who came after would be able to point to that, or UBS would point to that and say, that issue's been decided. So we don't have to relitigate it. But when you're in arbitration, you've got to relitigate everything. Doesn't matter. There could be 150 arbitrators who before have come out one way. You still have to establish it all over again. Not a single one of those is precedent. So that's not great. If mandatory arbitration, or if arbitration were so great, we wouldn't really need to make it mandatory. And that's something that I'm an advocate for. I think that we should have an investor choice as to whether to go into arbitration. That would cause FINRA to make the arbitration that they are offering better, attractive, so that they could win people over to resolve the dispute in FINRA arbitration.
Okay, regulatory capture has been a popular topic the past year. What's your opinion on regulatory capture in today's environment, and is it as rampant as it's made out to be?
Regulatory capture, it happens, and it happens in every agency to some degree. But I've had a lot of experiences at the SEC where they fight to be independent. And let me give you an example. I mean, the SEC is pretty scrupulous about trying to protect its independence. When I was there, we had the donut rule. And the donut rule was that if, like let's say I and another attorney were going to a law firm, for to look at documents or for a meeting or something. When we would go there, we by like the rule of the SEC, we were not permitted to eat or drink anything that was really worth more than a donut. Like we could have a donut. We could have a donut or a cup of coffee, but if they put out lunch, if they, brought lots of fruit, anything like that, like we couldn't have it. And we just knew that was a clear rule. You did not do that. So that's why we called it the donut rule. It was you could have a cup of coffee, a glass, bottle of water or something, but a donut, but nothing more. And so that was just a very clear guideline that we had. And part of it was, I think, to remind us all the time when we were dealing with these outside entities that we were supposed to be scrupulously honest. So and I'll tell you that continues today. Like, for example, when I go to the SEC with a client to give testimony, I'm a big fan of like having lots of sugar and stuff to keep, both my energy level up and my client's energy level up, because these are long days. So I will bring lots of yummy things. And my mom raised me right. I bring enough for everyone. So there might be, 4 SEC people who are in the room. I make sure that I'm going to bring, when I come, I bring a ton, because I want there to be enough for everyone. But I will tell you, there has never been a time that I've done that anybody's taken it. And that's in part the donut rule. Like they don't want to cross that line. They want to be scrupulously independent and try not to, experience agency capture. So they are very different from, let's say, the Federal Reserve, where the Federal Reserve has examiners who actually live in the banks, but they have offices, at these big banks, and they are there and they go to the Christmas party that's held at the big bank. I don't know if that's true anymore, but it was for years. They almost were like employees of the bank. I mean, they spent more time with the bank's bank personnel than they did with their own colleagues back at the Federal Reserve. And that's a way that, you kind of lose touch with, or you lose your independence.
Yeah.
And so the SEC tries. I mean, I have to give them a lot of credit. They try. I think it becomes more difficult when we're talking about the regulation side, and the SEC hears over and over and over and over again from industry and doesn't hear from retail. And that's the bigger problem. I think it's less the issue of regulatory capture, and it's more like the retail getting drowned out or just not being heard from. And there are organizations, by the way, that try to get in there and advocate on behalf of retail. And I don't want to, miss this opportunity to kind of give a shout out to some of them. I mean, there are people like Dennis Kelleher is at Better Markets. And, he's a staunch advocate for retail, and they put in comment letters often. Barb Roper, Micah Hauptman, or the Consumer Federation of America, they've done great work. Tyler Galash at Healthy Markets. These are people who have put in comment letters, have testified in Congress, have really been advocating for a long time. And I don't want to forget to mention, the Public Investor Advocate Bar Association, which is my bar association, and the Piaba Foundation. And, we're much smaller than these other organizations, but we try to get in there and comment too. We try to balance things out just a little bit, but it's still David and Goliath.
Okay. That was a perfect segue into this next question. You've got the eyes and ears of hundreds of thousands of retail investors right now. What actions can retail investors take to enact change?
Well, that's intimidating. Right? Did I mention that investors should submit comments? Because I think that's kind of a big one. I think that's number one on my list. That is absolutely huge. If the SEC starts hearing a lot from retail, that will have an effect on the SEC, and that will get noticed also in Congress and in the industry. And the industry might be a little more respectful and might not, propose such crazy things or be quite so greedy. So that's number one. That comment process is an open door, and we retail advocates, we should be just walking through it. Another thing is to learn about and maybe join or support some of those organizations that are doing this kind of advocacy. And that doesn't mean you give up your independence. I mean, you certainly can look at what they're doing and decide. Sometimes you have common interests with them. Sometimes you may disagree with what they're doing, and so you don't want to do something with them. But they're doing some work, and we're all just like apes build on each other. That there's this collective knowledge that comes out. Take advantage. There's a lot of stuff that people post on their websites, because when you're doing this for love, not money, you want to share it. You want to get all that information out there. So that's definitely a way to go. Another option, and I've actually been contacted by people about, apes are talking about creating advocacy organizations. And I think that's also a great opportunity, great way to approach things. So it's a lot. I will tell you, as the president of the Piaba Foundation, it's a pain. There's a lot of overhead that goes with having a 501c3 or, other organizations. So just so you know, before you get into it, sometimes it's nice to coast on somebody else doing that work.
Yeah. Separate from retail attempting to act as an agent for change, do you see any events occurring which will fast track fundamental reform?
This was one I thought about quite a bit. And I think the two things that I think are really going to change the world that we're in, the markets, the way the markets operate, are technology and the ability to move money across borders. And they're kind of related. I'm a fan of blockchain technology. And that doesn't mean that, I don't own any Bitcoin, and I'm not a, Bitcoin evangelist or anything, but and that's because I feel like blockchain and Bitcoin are in the stage of their development, just like the railroads were in the 19th century. And at that time, railroads were great technology, revolutionary, it made a difference. And blockchain is too. But we don't know exactly which companies are going to work out. And so sadly, I sit on the sidelines with my retirement account, and I'm waiting to see how it works. I'm certainly, I want to help with it, and I am a supporter, but it's just like, more recently, the dot-com bubble. Like, boy, if I had known which companies were going to, the ones that were getting online and creating websites, and say, if I could have picked out Amazon, oh, that's the one that's going to succeed, yes, I would be a very wealthy woman, but clearly I do not have that ability. And I think lots of other people don't also. So I would have been the one who invested in pets.com or one of the other companies that went bankrupt. Anyway, this is the revolutionary technology. And I think that the reason it's really going to affect the markets is that it creates another way for companies to raise capital to be able to do their work. And it's a way that is off the beaten track. It's not your issuing an IPO and showing up at the New York Stock Exchange and doing it in that method. I think that's a challenge to the status quo. I think we're already seeing the big players move their way into it, but there are exchanges being proposed. There are big changes coming, and I'm keeping an eye on it. And I think that it's good to have that alternate way to be able to raise capital, certainly, complying with the securities laws, but that doesn't mean that it's not going to be a challenge to these current participants in the markets. And I kind of wonder, like, how would you do high frequency trading with, blockchain interests, units in a company on blockchain? That would be hard, wouldn't it? So we'll have to see, how this all works out. But the other thing is that right now, I think to some extent, the U.S. securities markets are almost victims of their own success. Yes, we're the largest, markets in the world, but not necessarily the best forever. The way that we're doing things right now it may be working out, and it may have worked out, and attracted capital from all over the world for many years, but that's not a foregone conclusion that everybody will be flocking to invest in, through U.S. markets 10 years from now, 20 years from now. And that's something that we have the ability, we in the United States, to look at the future, or, think about how we want to position ourselves going forward. There's no reason that that Europe is doing different things. For example, the EU has banned, or is in the process of banning, payment for order flow. The US hasn't done that yet, that I know of. Clearly,
Definitely
that's still
not.
allowed. Right. Now, if that works, lots of people could decide to invest through European exchanges. I mean, there's nothing that prevents money from moving to a place that is more attractive, possibly, than U.S. exchanges. So we cannot just rest on our laurels, and we cannot just assume that if abusive trading is going on, if we have 90 to 95% of trading happening in dark pools, off lit exchanges, if we have high frequency traders who are, sort of taking little bits from retail over and over and over again, people can move. They can decide, there will be other markets in other parts of the world who will figure out how to make it easy for Americans and for everybody else to send their money that way.
Good. I just want to double check because we're about like an hour. Are you good for like another 20 minutes, do you think?
Oh, yes. Yes.
Okay, cool.
I'm fine.
All right. Just wanted to double check.
I can talk about this stuff forever.
I know.
And I have
the spaces. I'm like, oh my gosh.
I have so much fun. Like, and you guys ask great questions. So like,
thanks.
this was all like mental calisthenics. I'm like, oh my God, I want to look at this more. So anyway, sorry.
Awesome. Okay. All right. So let's continue on.
Sure.
With some general questions. Retail certainly has a diverse array of opinions on both the SEC and the current SEC chair. Do you have any opinions on Gary Gensler, current SEC chair?
I do have opinions about Gary Gensler, and I really like him. I like what he did at the Commodity Futures Trading Commission. He worked incredibly hard and fought industry in implementing lots of the Dodd-Frank reforms. So that makes me like him. I like that he is not a lawyer. I like lawyers, but as a chairman of the SEC, I also like to see the occasional non-lawyer come through because lawyers tend to be more status quo, slow progress type people than business people. Now, he's not reckless by any stretch of the imagination, but I think he's more progressive in terms of being open to thinking about changing fundamental parts of the way the markets work. Just the fact that he was comfortable saying 90 to 95% of trading is taking place off lit markets. He is the guy who's willing to say the emperor has no clothes, and that's not something that happened just yesterday. I mean, that's something that Jay Clayton could have commented on, but didn't. That's something that there's a lot of people, at the SEC, lots of other commissioners or staff people who've known that, and we haven't heard it from them. But he told us that. So I don't want to beat him up for telling us that. I want to say thank you for telling us that. Thank you for being willing to say that. And what can we do to help to reform this system that you, Gary Gensler, and we, retail, recognize is badly in need of reform?
Well, yeah, actually, let me ask you this question. Having experience in the position of SEC branch chief, what issues do you see Gary Gensler facing while trying to implement retail-friendly laws? And is there anything retail investors can do to help facilitate these changes?
Well, one of the problems that Gary Gensler is up against is the industry. I think that's the obvious one. The status quo. People people in the industry have curated these regulations. They've learned how to accommodate their businesses to these regulations and how to make money. I think the part that that most people don't think about what he's up against is the SEC staff. The SEC is a big juggernaut with a whole lot of people, and many of those people have spent an entire career there, and they are experts in certain areas. So let's say I'm the person who is in the Division of Market Regulation, and I am the expert on dark pools. Everybody comes to me and I know everything inside and out. I know all the players. I know exactly how it works. And Gary Gensler says, you know what, we're going to eliminate dark pools. How am I going to react to that? I'm probably going to be pretty bent out of shape because my entire career, everything that I've done will become fairly obsolete, in a heartbeat. So it's not as extreme as that. That's just a really big example that I can come up with. But there's a little bit of that that affects, I think, a lot of the staff. And particularly the more senior staff, people who've been there for many, many years and have made their name and really know how the process works. And then somebody says, nope, I'm going to change it. It's going to work a different way. And, people don't like that. Now, there are some people, I'm sure, in the SEC who are delighted and who think this is great and who think he's doing exactly the right thing. But I seem to, recall that people at the CFTC were none too pleased. He's when he was the chairman there. I will say he's a hard charging guy. And so that might not be too fun, to have somebody come in and be super smart. Let's say, he gets, people are talking about crypto cases with him. Well, this is a guy who knows crypto. He knows blockchain. He taught it at MIT, right? I mean, he's on top of it. That'd be pretty scary, don't you think? As a staff person, like saying, okay, I'm going to explain to you now, Mr. Chairman, what's going on in this case. And, it'd be kind of terrifying to think, what question is he going to ask that I just don't know the answer to? Oh my God. So that may be some of it too. But that's something I think we don't think about. So I'm all for, I have to someday get around to ordering Gary Gensler bobbleheads, because I have a Charles Ponzi bobblehead. Well, it's not mine, it's my husband's, but I'd say it's mine. And but I would love a Gary Gensler bobblehead, because I really do support what he's doing. He came in, he's got his regulatory agenda. He wants to, and has articulated that he wants to make a lot of changes. And that's a big deal. He's just not there, kind of hoping to keep the lights on and the doors open. He wants to make things better. And he's pointing to things that are obvious problems that everyone knows are problems, but that we haven't been talking about in the past.
Yeah, that makes sense. So do you think commenting on his, proposals and things like that would help him out?
Yes, we need to let him feel the love. We need to let him know. I mean, we don't have to say that we love him, but think about, he goes into a meeting and a commission meeting, or he's he wants to do something, he wants to reform, and the other commissioners maybe don't you think that pointing to but there were 2,000 comments that came in from retail in support of this? I think that helps him. I think we want to be like the wind in his sails. We want to be speaking up. Give him that ammunition. And the other way that helps is that when he can say, and when Congress knows, this is a guy who gets hauled up in front of Congress, pretty often, just like the Federal Reserve Chair and various others. But so when he gets hauled in there and they're questioning him and saying, why are you changing things, Chairman Gensler? What are you doing here? My constituents like it the way it is. Let's let him say, hey, retail investors want this. This is not just me, Gary Gensler, saying, oh, I think this is a groovy idea. No, this is what retail wants. And then you put, these Congress people in a pickle, because they have to say, well, who really cares what the people want? I want to do what my big contributor wants. So we can help him. And I'm excited about that.
Okay, good. If you were in Gary's position, what would be the top of your list to change about the regulatory landscape of securities?
Wow. Yeah, this was good. He's got such a tough job. And one of the things that I was thinking about is, there's so much to change. There's so much that has gone wrong. So, but how do you get things done? Because he's not going to be chairman forever, right? And a lot of these things are going to be battles. And if you take on too much and you say, okay, look, you know what? We got to get rid of FINRA. We got to get rid of these SROs. And that's almost biting off too much. It's not going to be successful because it's too big. So here's what I thought. This is the SEC is a disclosure agency. It's all about, transparency, disclosure, getting information out. So I would, my number one was get rid of dark pools, because I just don't see how something in a dark pool really fits in a securities regulatory environment that's all based on transparency and full disclosure. I really don't get it. I don't care that there are certain institutional traders that don't want the size of their trades, to be public. This is life, okay, figure out a way to make it work. And I certainly am not interested in protecting high frequency traders. What benefit do they confer on, Main Street America? They're not, their transactions, their transaction cost, really, they're not raising capital that's going out and, building bridges and things. So that's my first one. I might go so far as to say they're almost like the dark pools are like a cancer on the US securities markets, and we could excise them. And it just seems like an easy thing to do, except for the fact that they're all powerful and, will have huge amounts of money to protect their current system. The second thing is I really would change and simplify and impose a system of real disclosure of fees to customers. And the SEC sort of made an anemic attempt at this with the CRS form. And it really was anemic. It was more confusing, I think, than some of the previous disclosures. If I do business with a broker, I should know what money that broker is going to make from me or made last year, and how. And that still is not something that the SEC is requiring brokers or registered investment advisors to provide. And that just makes me nuts. I have an account at Fidelity. I have an account at TD Ameritrade. Okay. So Fidelity was the one I picked. I decided, okay, I'm going to do a little research and see if I can figure out, get all the fee information. Oh my God, after about 15 minutes of like futzing around and looking on the website and trying to look at different forms and figuring it out, I gave up. And I'm in this industry. So how transparent is that? I mean, I know for a fact Fidelity has affiliates that provide custodial services. I know Fidelity has affiliates that do the management of the mutual funds. They have, various other entities, and yet I can't, it would take me a vast amount of time to be able to figure it all out. So how is that transparent, and how is that full disclosure? I just don't get that. So another thing I did was I entered, a couple trades and in my TD Ameritrade account. And then I wrote them a little message and said, hey, can you tell me how much did you make in terms of payment for order flow for these trades that I entered? And of course they told me, oh, go look it up. We don't tell you what you've earned, on a per trade basis, but you can see what our payment for order flow policy is. And again, don't send me running all over the place. There should be one place where you disclose this. It should be on a confirmation. It could be at the end of the year. So, I mean, the SEC routinely brings cases against people and companies for failing to disclose material information. And yet, the SEC is permitting these entities that are operating under its supervision to fail to disclose material information. I would really stop that. It doesn't make sense. So another thing that I think it would be reasonable is, and I loved hearing Ryan Ronan's AMA before when he talked about the like they do things in a simple way rather than the complex way, and that they could explain their fees in a tweet. I think that's great. So complexity is a way to hide things, and yet the SEC has permitted just complexity on top of complexity, and things just keep getting more complicated. I think this really does require somebody like Gary Gensler stepping in and saying, okay, no, we've got to get simpler, not more complex. Okay, third thing that I would do if I were the grand poobah of the SEC, I would get rid of mandatory arbitration. Absolutely. You are on the money on that one. You brought it up before. I think that the public should have access to this information. I think that there isn't anything special about a customer brokerage firm dispute that should force it out of the courts. I think we also would have more efficiency, because we would have certain cases would be decided, and then the other ones that came after, there would be this thing called a precedent. And that's what happens in the law. When you have cases that are decided by judges and they are reported, they become precedential. So then people know what the rules are going forward. Whereas when you have arbitration, it's always a free for all, because you never know. And you get to decide what the rules are over and over and over and over again. The rules don't have to be consistent. Certainly don't have to be consistently applied by the arbitrators. It's crazy, really. So that's one. The fourth thing is, and we're back to my near and dear to my heart, broker check. I would fix broker check and make sure that when customer complaints are reported, that the right ones are reported, and that a broker can't just go through a sham proceeding to get some cooperative arbitrator to tell them, okay, you can take this off, and then go to a court and misrepresent that actually was a real proceeding, that arbitration, and that a court should respect it and confirm it, and then take the customer complaint off. I think broker check should have a giant warning on the front of it. Warning, this information is not complete. That's the first thing I would put up there until broker check got fixed. So those are my big four. I stopped at 4.
You can keep going.
No. I thought I should stop. I know Gensler has a much longer list and far more detailed. Yeah.
All right. Well, thank you. Everyone faces some sort of subjective bias. Some biases are more public-facing than others. Do you believe speaking fees present a conflict of interest?
I think they do, but I don't think the SEC accepts speaking fees. I think they are prohibited from accepting speaking fees. And I say that because when I'm at events with the SEC folks, sometimes they don't even eat the meal that's put out. I mean, again, we're back to the donut rule. No, that they really are scrupulous in making sure that they're not accepting anything that could compromise their integrity.
Well, that's good. Well, here's a good question. Currently, the DOJ are investigating banks on a number of topics, including block trades and short selling. Do you have any thoughts on what the outcomes of these investigations might be?
No, I don't really know. I think this is such I'm following it. I'm interested. I'm trying to figure it all out, but this is such a wide open and new area that it's really hard to know. I mean, for DOJ to be looking into it is pretty exciting. It's complicated technology. The standard of proof for DOJ to prove, a violation is really high. I don't know. This is a tough one.
Yeah. Well, I'll have to sit back and watch and wait and see. How can it be legal for a company to be shorted over 100%? And how can that be prevented in the future?
Well, this is a tough one, but our system of our law permits a stock to be shorted, the same share of stock to be borrowed for the purposes of a legal short over and over and over and over again. Now, I don't think anybody really thought that shorting, when they drafted these rules and laws, thought about the fact that the things that we are seeing today could happen, but they have. So yes, it's legal, but that doesn't mean it has to remain legal. What is wrong with saying that we will change the rules and only permit a single share of stock to be shorted a one time, to be borrowed to cover a short one time? Why not? We can do that. We have the technology, I believe. But if we don't, we certainly will at some point in the future. And there, once again, we have blockchain as a potential way. Maybe they can solve. People developing these systems on the blockchain might be able to solve this problem. But it seems to me that when we have a share of stock that's out there, I used to write computer systems. Now, granted, I wrote them way back when we were doing them on IBM mainframes, and they were like big, clunky things. But there were these things, we had these little fields where we could like put markers, we could indicate things. And I think they still exist. I mean, computer systems are different, but still there are little fields where you can enter something. You could enter like a little check that says, this share of stock is no longer available to be borrowed because it's already been borrowed. And that just seems like something technologically we could do and legally we could do.
Actually, I got to ask you a question from somebody who's just like backstage listening.
Sure.
So he said, speaking of legality, is it reasonable for retail to get the law changed in regards to companies being able to advertise direct registration services?
Boy, would I be excited about that. I don't know about direct registration services. That is something I have learned about from the apes. And so I'm actually in the process of doing that I've got some GameStop and I have some
computer
AMC.
share. Yeah, we got to get your shares into your name.
Yes, I'm going to do it. No, this is like just to be irritating. Just like, I don't care how much time it takes. I'm going to figure it out. I'm going to do it through computer share. I mean, it's just one of those things. It's like, I want to figure out how to do it. It was part of the reason I was doing those TD Ameritrade trades. It was like, all right, I'm going to get my GameStop, get my Ameritrade. It's not a lot of AMC, but my husband looked at it like, what the heck is this doing in our retirement account? Like, well, honey, we happen to have some cash in that retirement account. I didn't have to sell anything, So yeah, but that I'm learning about it. So I'm sorry, I don't really know about the direct registration system. I will in a couple of months, I'll know.
Oh yeah. Basically, like we all wanted it not to be seed and company. We wanted it in our names, that kind of thing. And to have, if there were ever dividend, it would be easier, get it right to you. And we had a bunch of problems where a lot of investors couldn't even vote.
Yeah, right. Because it's in street name. Somebody else has your
right.
vote.
So without voting rights, what am I doing? Right. So we all kind of figured it out.
Oh God, wait till we start talking about that. I imagine that, that Supersonic, 2.0 is going to be all about Delaware and corporate shareholder kinds of rights. Oh my God, because that is just a whole world of crazy too. So
Oh yeah, for sure.
yeah, but this has been so impressive. I'm learning a ton, and and unlike lots of people, like I like finding things I just don't know about.
Oh, me too.
And kind of, yeah. And I feel like this is a community of people where, like, unlike some of the folks, that I occasionally work with who are like, I don't know that, and I want to get into that area. It's like, I don't know it, but now I have something to like delve into and kind of go down the rabbit hole.
Yeah. Yep. Can I ask you one more question? Sorry,
Sure.
I keep writing questions on my paper.
No, that's okay. I'm here.
Actually, there's two, but okay. Are there any tools retail might not know about that could aid in our research?
Boy, that's a good question.
Like, okay, so for one thing, you said that you couldn't even see the customer complaints. Where do we even put the customer
Yes.
complaints?
Okay. So I am going to do a video on how to find the stuff that's been expunged from BrokerCheck. An important resource. That was a good question. I'm so glad that I'm here to answer that. So FINRA Arbitration Awards, when you put that into Google, you will, and it is, you can't find it. You go into FINRA's website and FINRA's website sucks.
Yeah.
They make it hard for you to learn anything. And so you have to do it via Google. That's how I do it all the time. So you put in FINRA Arbitration Awards, then you will be able to search on the name of a broker, and then you will find those decisions that permitted that broker to be able to remove the customer complaints. So let's say you do your BrokerCheck research, you look at a particular, individual, but before you come to a decision, you then have to do step 2, which is go to FINRA Arbitration Awards, put the broker's name in there, and see if there have been expungements. And that, isn't that ridiculous?
Yeah, that is crazy.
Yes. And you know what? That's something that not just we as retail have to do. That's something that the regulators have to do.
Oh, no way.
Because it disappears from the BrokerCheck is created from what's called CRD, the Central Registration Depository or something. Anyway, CRD is the home of all of those records, and that's run by FINRA, but it's owned by FINRA and the state securities regulators. But anyway, so that's what, let's say I'm going to, I'm the Minnesota Securities Commissioner, and I get an application from Joe Smith, and Joe Smith wants to do securities work. He wants to be a broker in my state. So I'm in Minnesota. Well, I'm a state. I don't have a lot of resources. So what do? I look up on CRD and I see, oh, well, Joe Smith doesn't have any complaints. Okay, Joe Smith approved, go ahead. Well, I now, as a regulator, have to do that extra step to find all the stuff that's been expunged. Wow. And most regulators, like, what is the point?
So would it help if we found them all and sent them to you guys or something?
We actually know, and we're in the process. That's a project that is on, like, we have a website, nice. A couple domains that are set aside for that. So it's really just a question of like bandwidth, but that we could definitely talk about that, because
that's awesome.
What we have talked about, the process of creating the real BrokerCheck, or calling it Broker Verify or something. I forget what we call what the domains are that we've got set aside. I should know that. I just saw them a couple of days ago. But that's like, okay. that is our plan, that we have the ability to be able to go and what's going to happen. We have to assess, like, well, the brokers will sue us. Of course, but it's still public out. It's a public record. So we just have to kind of think, we have to, the mechanics of doing it. And anyway, yes, it's a very exciting
I love
project.
that. That's awesome.
Oh yeah, no, this is why, I love being in Piaba and the Piaba Foundation. It's like, this is the stuff, like when we're, sitting around thinking about fun things to do, it's like, yeah, this is what we want to do. Yep.
Yeah.
It's exciting.
Yeah,
So,
definitely.
yeah.
Well, okay, so sorry. The last thing. What do you think is the most likely reason that the SEC doesn't just turn off dark pool access?
Well, first, because I don't think that they feel the pressure to do it.
Oh, really?
So
Wow.
that's number one. I think, right now, yes, they're hearing a little bit of squawking about it, but it's been approved. It's legal. So it's the status quo. And it's always our burden when we want to change something. How do we undo that bad thing that happened? We didn't know exactly what would happen when they created these ATSs. They certainly didn't look as evil. We didn't get into, one of the biggest things that and again, there was like so much I want to talk about, but one of the things that I think has been devastating for retail is the repeal of Glass-Steagall. What the heck do we need to have banks doing brokerage work and brokers doing bank work? This is nonsense. It's the same kind of craziness that brought down Arthur Andersen. It's, we don't want auditors doing consulting work and consultants doing auditing. No, we need banking to be boring and simple and safe, right? That's banking. We need brokerage firms to not be doing like tons of prop trading. Why can't we have these kinds of separations? Why do we have to have a JP Morgan Chase? It doesn't make sense to me.
Yeah.
I don't care that we have to do that so we can compete with foreign country, other giant behemoths that are in other countries. How about we compete for fairness rather than we compete for bigness?
Yeah, right.
Seems, it's a thought, but let's say, Canada gets it right, or Australia gets it right, or somebody else gets it right, money's going to flock there.
Yeah, true.
So how did you get involved in all this?
So I downloaded Robinhood like January 25th and was a part of that whole mess where, I bought GameStop, it went up a ton, and I was like, just wait, they'll turn it back on. This must happen all the time. You know what I mean? I didn't know what was going on. And then after that, just like, I just couldn't help but like dig into what, like, because that's just like such a thing. Like, how could that even happen? You know what I mean? Where it was just like, everyone was like, oh, this shouldn't happen. There's something not right here. And then once you start looking, then you realize, wow, there's a lot of things that aren't right, and I don't know. So I just stuck around.
Wow. No, it's great. I love it that's the approach people took, that, because sometimes people just get frustrated and they just say, forget it. I'm not going to, look at how long these markets have been using these kinds of techniques and had this kind of structure. And I'll be honest with you, I've learned a ton about it. I didn't know about it, that like a lot of the ways that these things work. When people send like reports of shorts, like, I never looked at one of them before. Wow, that's kind of cool. Yeah, we should get that stuff more often. That'd be really useful.
Yeah, right.
So, yeah, the difference in the way people responded to this, I think, is huge. And the other thing that kind of, struck me was, I started off thinking, because I'm a vanilla investor. I'm a very simple woman. I have index funds. I have total market index funds. I am boring when it comes to my investing. And so, I think I own a stock. I own like the Berkshire Hathaway B shares. That's like a mutual fund, but that's it. So when this all happened, I had the typical SEC bias of, well, people are buying, these are young people buying individual stocks. What are they doing? They're trading, they're speculating, they're blah, 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 and that was just like the Jason Zweig had it, from Wall Street Journal, the reaction of there are traders and there are investors. And that very shortly after that, I started seeing like, no, these are people who are holding. These are not traders. These are people who are in and holding. They're holding longer than lots of Main Street investors. Whoa, whoa, whoa. We got to stop like this dichotomy. And frankly, even if they are trading, and even if they're buying it to screw the short sellers, more power to them. Why shouldn't they be able to have a level playing field with, Citadel and Goldman Sachs? Like, I don't see where in the securities laws it says that retail investors only get to do these humdrum sort of things and not do the really fun stuff and interesting stuff and make change in the market. So anyway, that was a kind of an epiphany for me of changing. So you guys have really changed the way I view the markets and what we should be doing.
How many comments did you used to see, like on proposals and stuff from retail? Like 5?
Zero.
Oh, really?
0. Yes. Yeah. There would be some from organizations. Sometimes in some cases, there aren't very many comments at all, even from industry. But, even on hotly contested things, you'll only see comments from people in the industry, and then organizations that represent, or purport to represent retail investor interests. Yeah. So that's it. So this is a real watershed moment. I can't tell you. That's why I was moved to tears. I truly.
Yeah, there was so many February 7th. I saw those too.
I want to go back and I just want to like figure out how I can save that whole page, because that just, it's amazing. I've been telling all my friends about it, like in the Piata community, like, you guys have to see this. This is amazing stuff. Like, look, our clients, we often send messages to our clients like, hey, this thing happened and this was an issue in your case. And can you send them a comment? And people don't do it because, they moved on in their lives and whatever. But you guys all showed up and commented. That was brilliant. That was so incredible. So mountains can be moved.
Yeah. That's so awesome.
Yeah, I am so much more optimistic than I was before this morning when I saw that.
Good.
Yes. And I'm going to, we'll all just keep fighting.
Yeah. Well, we need to keep in touch because you are coming out with this better broker check thing.
Oh yeah. No, definitely send your email and your contact info. I have your email, but I don't have like,
I can probably give you like my
and like a real name or something.
Yeah. Exactly.
I know, it's so funny. That's like a whole other world too. It's like, maybe I shouldn't have put my name like as my Twitter handle, but whatever. But I'm generally trying to like have people know who I am, but it's so funny. I'm like, oh yes, you're like, wears stinky socks. Thanks for your comment. Wears stinky socks.
Mm-hmm. Yep.
But I'm used to it now. So it's really been a pleasure. You did a great job.
Oh, thank you.
This was fun.